Hi, John McGowan, General Secretary of the Social Workers Union here, and good evening to you all. It's brilliant to see so many people registered for this event, and we'll do our best to answer as many questions as possible. I can see a large amount of attendees on this session, so I don't think we'll get through all the questions, but we'll do our best, and hopefully we might have a future webinar. The event is being recorded, but please remember that any advice is as of today's date, which is the 18th of December. I had to think with that, the 18th of December, that means it's 1 week to go till Christmas. I would really have to get my Christmas tree up. So hopefully it will be available later on the Basel website, and working hard behind the scenes are the talented Steph and Jane. So I want to take you through some housekeeping bits. Please ask any live questions in the panel box, and it's to the right to your screen, and Steph and Jane will do their best to make me aware of them and for the panel to answer during the session. My advice is to keep them brief and also non-identification factors to represent, obviously, confidentiality. Before I introduce the panel, I just want to emphasise the importance of joining a trade union. Of course, I'm biased and firmly believe that the offer of a professional association, which is BASWA, and a specialist trade union, which is SWU, working together is an offer to consider, particularly as we've got a lot of non-members on this webinar tonight. There are, of course, other trade union options for social workers, and I personally really wish that we could all work together, and my door is always widely open for collaboration if any other unions are listening. Now, over to the important people on this webinar. It's the panel and it's the expertise. I'll change the slide now, and I'll get each panel member to introduce themselves. We'll start with Paul. Paul, would you like to introduce yourself?
Thanks, John. My name's Paul Scholey. I'm a senior partner of Morrish Solicitors. We are a legal firm doing work for trade unions, over 24 unions and associations. I've been an employment lawyer for 30 years. I act only for people, not companies. And I'm particularly interested in the law relating to social media.
Thanks, Paul. And Laura, would you like to introduce yourself, please?
Hello there. Yes, I am Laura Sheridan. I work for our advice and representation team. So I work as an advice and representation officer and trade union official for SWU. Our team work around the country providing advice and representation to our members on a wide range of employment issues, from disciplinary to capability processes, discrimination issues, sickness management issues, and a wide range of employment processes.
Thank you, Laura. And Leanne, would you like to introduce yourself?
My name is Leanne Watts. I am the head of the Advice and Representation Service, so I manage Laura and her colleagues, all officers and trade union officials. I'm also the Assistant General Secretary of the Social Workers Union, so I support John in those different kind of union type matters as well. I think that's all I can tell you at the moment.
Thank you, Leanne. And for non-members, there's a handout which has everybody's details on it, and also how you can join BASWA and SWU together, and that's useful for you. So you can look at that at the very end. It's up now just for you to see in case you're keen to do it right now, actually. But what I propose I'm going to do is I'm going to try to extract some questions and direct them to each panel member, so you need to bear with me if any technical problems, but I'll do my best. So the first question I'm going to put to Paul, it looks like a legal question, and it says, I work in a local authority and have relocated to another local authority area. I have a fixed term 12-month contract, and my line manager is bullying me and others. What are my rights? I feel that my contract of employment will be at risk if I raise a grievance. And the second part is, what legal remedies are available if I am the victim of bullying at work? So Paul, it's a double sort of strand question there.
Yeah, thanks, John. The legal position is not terribly helpful for you if you're being bullied in the way that that's been described here. We, surprisingly perhaps, do not have in the UK any formal anti-bullying legislation. There was at one point a suggestion that we should have a Dignity at Work Act, which I for one would have supported, but it never went anywhere, and we're left in a position where unless you can complain that your treatment by your employer relates to a protected characteristic such as race or sex or disability or religion or whatever, then the reality is that there are very few direct remedies that you can take advantage of in, say, an employment tribunal to tackle bullying from management, say. The standard advice that you'll get from a lawyer is that the way to deal with it is to leave. And you may have heard of a sort of claim called constructive dismissal, which is a flavour of unfair dismissal claim. So if your employer has acted in such a way that the relationship between you and them has been completely undermined and you can no longer continue to work, then you can, technically speaking, resign and say that resignation represents, in effect, a dismissal, because what option did you have? But it's a hopeless remedy for all sorts of reasons. Firstly, unless you've been employed for 2 years, and in this case, it's not clear that the person asking the question has been employed for 2 years, unless you've been employed for 2 years, you have no rights to claim unfair dismissal. And even if you have been employed for 2 years, are you going to walk out of the job and leave yourself without an income, without necessarily another job to go to, purely on the basis that you may have 6 or 9 or 12 months down the line a chance at a tribunal of recovering some money? And bearing in mind further that if you get another job, then any money you earn in the other job will reduce the value of your unfair dismissal claim. You're not guaranteed to succeed. Your legal costs won't be paid unless you're a member of a union. Your legal costs won't be paid even if you win your case. It's a hopeless situation for employees in this sort of position. And the best advice I would give, and I would say that wouldn't I give in present company, is join a union and bringing the union for internal support. And yes, lodge that grievance, because most larger and public sector employers will not immediately make you, I think, into a double victim by leaping upon you if you raise that grievance. I think raising the grievance does cause most respectable employers to insulate you, at least to an extent. And certainly if you've got trade union representation, that can create a framework within which some attempt can be made to improve your situation. And even if in the last analysis the improvement's going to be leaving, then your union rep can help you negotiate an exit strategy and a package that, in my experience, is miles better than a litigated solution through the courts or tribunals. So it's a long answer, but it's a big question.
No, it was a good answer, Paul. I'll just ask my colleagues Leanne and then Laura just to see if they've got any comments in relation to the question. So Leanne, anything to add to Paul's advice there?
Yeah, I would agree with the issue of constructive dismissal. It's a very, very high threshold to get over, and as we certainly don't recommend that as the first course of action ever. One thing I noticed is that you say that you are being bullied, but also others as well. So of course you could do a group grievance, and then you're not, you know, the safety in numbers, you're not singling yourself out. So I think you could probably talk to your colleagues and see if they would be prepared to join with you, and that would strengthen your case as well. Clearly, if there are more than one employee, you know, raising issues about a particular manager, then that's going to have a certain strength and weight to it as well. Laura, do you have anything else to add?
I think most of it has been covered very well. That the only observation I would have is that I would like to explore the question further with an individual member if they were having this issue. And I say that because I would want to explore whether or not there was any potential discrimination going on in this case. So that would mean that if the bullying was occurring as a result of you having a protected characteristic under the Equality Act, and I think we'll come on to this issue later on in the webinar, so I don't want to kind of delve into that too much now. With someone saying that there were a number of them being bullied, potentially it's not likely, but it's worth exploring, because, for example, if all of the staff that happen to be suffering bullying were from a particular ethnic group, for example, then that would raise the issue that we could potentially look at a discrimination, a grievance in relation to discrimination, and there may be some legal protection there. But that's, like I say, just something that I think is worth exploring more, and I would always urge someone in that situation to kind of seek that further advice, really.
Thank you, Laura. Thank you, Leanne and Paul. I'll move over to the next question. Again, if anybody's got any questions, remember to put them in the chat box. I'll do my best to extract them and I'm adding to the list of questions. So I've got a question, and I'll pass it on this one to Laura now. I'll work my way along to Laura, then the next one to Leanne, and back to Paul. So Laura, the social worker says, I've been employed as a social worker in a charity organisation for just over 6 months. My wife has recently been acutely very ill and has very poor prognosis. Do I have any employment rights? I would like to have a career break to care for the next 12 months. Do I have any rights?
Okay, I think in terms of employment rights, that's quite a big question, I suppose, and would cover a number of different areas. I think in relation to this particular question, what I would say is the first thing that I would do in this situation is I would then check the employer's policies, all of those policies in relation to policies such as compassionate leave, carers leave, and career breaks, because that whilst you might not necessarily be legally entitled to a career break, for example, according to any, there might not be any legislation in place that would particularly entitle you to that. But some employers do have policies relating to career breaks and will offer you that information as to how to apply for that career break. I think in terms of the actual employment rights and what you would have in relation to this particular situation, there are two things that spring to mind for me, and both of these fall under the Employment Rights Act. One of these things is that people are entitled to something called time off to care for dependents. So this is something that can be taken in the case of an emergency, for example. So if a dependent became suddenly ill, then you would be entitled to that time to do what you needed to do to support that dependent. And husband and wife are included in that definition of dependence. According to the law, you would need to let your employer know as soon as possible that you needed to take the time off, and try to provide an idea of how long you'd be expecting to be off for. Again, I would double check the policy, the actual employment policy in relation to what is offered for time off to care for dependents within your organisation, because there is the chance that a lot of employees don't actually offer money, so you won't get paid for that time off to care for dependents. So there is quite often a financial implication for that. The other thing that is springing to mind, or what I meant to say in terms of the time off to care for dependents, what I'm thinking of is in terms of the other provision is the flexible working provisions. So if somebody has worked for an organisation for 26 weeks, then they're entitled to make an application for flexible working. Now, obviously, I don't know exactly how long the person who's asked this question has been working for, but the implication would be that they would just fall into this period, so they would have those rights in terms of employment rights to make that application. So a flexible working application is pretty much as it says. You can apply to your employer to have your work hours made more flexible, so change of work hours, reduction of work hours, so if you wanted to go to full to part-time, or compress your hours, whatever would work in terms of your family caring commitments. Now, the employer is under a legal duty to consider that request and reasonably consider that request. They are not under a legal duty to grant that request, and there are a list of specific reasons why they can't grant that request or can refuse that request. The one that we quite often see coming back is for business reasons, so it doesn't help the running of the service if somebody is having flexible working, and we see that come back quite often. But there is normally a right to appeal for that, and the employer does have to show that they have considered it reasonably in terms of if they consider any alternative options for ensuring that service provision is able to continue. And there is normally an appeals process for part of that. So again, it's something that us as a union can support with and advise on in terms of that.
Thank you, Laura. So it's Paul, have you anything to add on to Laura's comments in relation to that question?
I just add this, that that from the way the question's framed, it seems likely that that the spouse is going to be disabled from an Equality Act point of view. So that raises this really quite interesting legal question of discrimination by association. Mm-hmm. And the short answer to that is that the law is not terribly helpful in relation to that, because what the law's concerned with is the employee, who's not the one that's ill here, not the one that's disabled, and they can't be treated badly because of disability. But what they'd be asking here is to be treated in a certain way because of somebody else's disability. And as the law stands, there are very limited rights in relation to that. It's something that we're asked frequently about, so I just flag it to say it's not usually a route that will be terribly helpful, and I think Laura's points are better ones.
Thank you, Paul. And Leanne, anything to add to that question?
No, I was going to bring in the possibility of disability discrimination as well. Paul's covered that fairly well. I think in reality it'd be, as you said, quite difficult, quite an unlikely path, but there may be some room for manoeuvre in arguing that in order to get your employer to perhaps be a little bit more compassionate and to help you through. I think I can't think of anything else.
That's fine. We've got lots there. Thanks, Leanne. There's lots of live questions, but there's a very brief one there that somebody's asking. Thanks for putting on this webinar. Well, you're welcome. Thanks for listening. Would SWU give any consideration to removing the qualifying 3-month period for representation? Of course, that's all fixed into if you've got a pre-existing case. But also, you know, I suppose we do look at individual applications for the circumstances. So what I would say is, you know, get in touch with the team and sort of discuss that further. So if anybody else is thinking about the qualifying period, but it is there for a reason, obviously. So thank you. Leanne, I've got a question for you now. I'm just going to read this. It says, I've been a social worker qualified for over 5 years, and I moved 5 months ago, and I'm keen to develop and gain experience and obviously a promotion. I've expressed an interest in a temporary senior practitioner's role. My manager has now informed me that if I wish to take up the 6 months secondment, I must resign. Is this right? So I take it it's a 6-month senior post.
Keep forgetting to unmute myself.
Right.
It's a pretty unusual approach to take. It struck me that the questioner says that they've moved 5 months ago, so I wondered if that meant they moved to a new employer just 5 months ago. And so the employer might have taken a long time to recruit to the position and might be somewhat annoyed that they're now going to lose that employee to somewhere else. They have to agree to it. The employers have to agree to it. And although it's a bit hard to say, well, you know, you have to resign, looking at it from the employer's point of view, they may feel that they just simply cannot replace that person easily whilst they are on the secondment. So in general terms, a secondment takes place when an employee or group of employees is temporarily assigned to work for another organisation or for a different part of the same employer's organisation, that is to a different department. So it depends on the terms of the secondment, what is being asked for, what backfill arrangements might be. There may be a secondment policy that you can look at. But ultimately, I guess the other thing to think about is liability. Who would be employing you? And sometimes with secondments, that is a tricky area to cover. So the first employer may be liable for any accidents or whatever in the seconded placement, or whether the second employer would be responsible. So it's quite a complicated area, and I think, well, it would be one of those questions where if we had a question like that through to our duty service, I think we'd be asking a lot more questions to clarify what exactly the circumstances were. So yeah, it's a complicated area, I feel. I don't know if, Paul, whether you can come in on that.
No, I think you've covered it. It seems to me that there isn't a right in law to take a career break or to be put on secondment, and in the end, you can always vote with your feet. But say for what Laura talked about earlier in relation to the right to request flexible working, which is a very different thing from a 6-month secondment, you're at the mercy of the employer helping you out. Otherwise, voting with your feet is the only way, I think.
Thanks, Paul. And so, Laura, anything else to add there, or will we move on to the next question?
I think we can move on to the next one, John.
Perfect. So there's some other good questions coming in here. So Paul, there's a legal one here. What are the main issues? This is for Paul. What are the main issues that I need to think about if I want to pursue a discrimination claim?
Thanks, John. These difficult cases. I'm afraid I'm going to sound like all the cases that we want to pursue are difficult, but some of them are. The problem, of course, is that most employers don't go about discriminating in an overt and obvious manner. By its very nature, discrimination is often hidden. Decisions are made behind closed doors. Discussions are had verbally without a written record. It's very rare, in fact, that we find the proverbial smoking gun that enables us to prove that the employer has been up to no good. The biggest problem we see in most of these cases is what we lawyers talk about as causation. So it might well be that I'm a woman, say, and I've not been promoted during a promotion round. And I conclude that therefore I've not been promoted because I'm a woman. And that applies to all the protected characteristics. If we're going to pursue the claim, we need to establish that there's a causative link between the detriment complained of and the protected characteristic, be it disability or whatever. And it can be hard to find the evidence to make that stick. So often what we're looking for are witnesses who can say, well, these are the things that were said that show that this organisation perhaps favours white employees or has an issue with people of certain sexual orientations or whatever. Remarks that have been made can be important because whilst there might not be a useful written record that we can hold up as a smoking gun, if a particular manager has got a reputation for making comments that are discriminatory or for harassment or whatever, then those are things that we can bring to the attention of a tribunal to say, look, there might not be anything that directly relates A to B, but you can draw some inferences. And tribunals are quick to draw inferences because they know how difficult it is to find absolutely direct and obvious evidence. So putting together from history, really, as many parts of the picture that as you can to show that it's possible, at least, that there's a connection between protected characteristic and the matters complained of is essential in these cases. And the other thing that's important, I think, is the culture of the organisation in terms of its approach to, say, training and support on equality and diversity issues. Lots and lots of employers have got wonderful 50-page E&D policies that say exactly how they will comply with their obligations in relation to non-discrimination. But in fact, apart from sticking these policies on their intranets or making them available in a staff manual in the canteen, they do nothing to make that thing live. And tribunals, again, are quite interested in this, and will take a view about the employer that simply says, well, here is the policy, read it and let's stick by it. And it'll ask the question, are managers given regular, and not just one-off, but regular and ongoing training and support in relation to equality and diversity issues? And if they're not, then that again is part of a picture that we can begin to paint that helps us establish the causation that we were talking about earlier. I could go on all day about it, but maybe those things as just starters at least give you an idea of the sort of issues that we'll have to look at if we're going to pursue a claim for discrimination.
Yeah, that's great. I'll ask Leanne and I'll ask Laura, but I think it's reality is it in a short time, an hour, I think in reflection and perhaps a longer time, because we've still got so many questions to get through, but it's a good starting point and a great answer, Paul. Leanne, have anything to add regarding the discrimination factors?
Yeah, just to say that finding the evidence, the causal links, is always the most challenging thing, but sometimes you can ask for information about how many disabled people have got, are in the company or in the organisation. You can ask for information that makes it perhaps a bit difficult for the employers. And that's sometimes a way of saying, well, look, we've checked the figures and there are no black team managers. And in an organisation of this size, you would expect them. Those are the sorts of inferences that I think Paul was talking about. So it's always worth looking at it and considering it as a possibility. I think you have to do that, but it isn't always easy to find that evidence.
Thanks, Leanne. And Laura, anything to add on to that?
Yeah, I would echo the difficulty sometimes in getting that evidence. Whilst as representatives we'll often think, I am sure that there is a discriminatory element going on here, it can be difficult to prove that. One of the things I would say is particularly difficult to prove can be racial discrimination, because we will be representing people. And I will often sit, far too often actually, I will sit and think, I am sure that this person would not be in front of this disciplinary panel or going through these capability proceedings if they happen to be white as opposed to black or Asian. But proving that can be quite difficult. One of the things we say to people is keep a chronology of events. Make sure you know everything that's happened from day one, because it might not seem like a big thing, but if there's a number of incidents where you've been treated differently, even if it's quite discreetly compared to your colleagues, those things can build up. And the other thing that I always say to people is do a subject access request, because sometimes those things can throw up something that is really really interesting, so to put it that way, and really highlights an issue of discrimination. So it's always worth doing a subject access request to get access to that information about any correspondence about yourself, because that could throw up some quite useful evidence.
Yeah, thanks, Laura. And I'll stay with you for your next one. It's I'm just reading this now. It says a referee has written a lie about me. This was a second reference and about 5 years ago. Do I have any recourse to complain now?
I think again, I would be wanting to ask more questions around that. I mean, the first thing that springs to mind is what would be the reason for the complaint? If it was such a long time ago, what would you be wanting as an outcome for that? There's obviously some reason why the complaint is necessary. I'm presuming that it could be impacting on this person's ability to be finding work, but I don't know without having that conversation with that person. I mean, generally, according to the law, a referee's got to provide a reference that's factually correct and that isn't actually misleading. So you couldn't give half of the information without providing the full story, and because that could give the wrong impression. So it's about how much truth there is in that reference. I mean, you're clearly saying that the referee has written a lie about you, so that would be unlawful. I think the difficulty is that most of the time, the majority of the time, references bizarrely aren't covered under employment tribunal employment law, and therefore isn't that recourse to a claim in an employment tribunal for a negative reference. It actually goes via the civil courts, and that would be for if you've lost earnings as a result of a negative reference. So it would be a claim for negligent reference, for example, via the civil courts. Now, what I would also say is that claims, if you were to go down a legal route, are time barred. So you would need to get legal advice about whether or not you could even kind of bring a claim for that respect, if that's what the issue was. I mean, I'm kind of making presumptions here that this is causing some kind of issue with employment. But the law does clearly say that it has to be a factual and an accurate statement. So I think it's about, you know, ascertaining what it is that the issue is here, and supporting someone to challenge it, and, you know, getting somebody to double check whether their claim would be time barred if they were to bring anything in the courts.
Yeah, thanks, Laura. Paul, from your perspective, anything to add on to that before we go on to Leanne?
I think that's a good answer. These things are hard to pursue, and we don't run many of them. It's fair to say the county court, high court is the only way that you'll pursue a misrepresentation claim. It's nearly always difficult for regular people to pursue claims for defamation, because there might be an element of libel in what's been said about you. But unless you're Elton John or Jeffrey Archer, then it's very difficult to fund that sort of case, and trade unions, understandably, tend not to want to get into the massive costs that involves. But tricky, and yeah, I think the point's well made.
Yeah. Anything from your side, Leanne?
The only thing I was going to say was that, of course, there isn't employers aren't obliged to provide a reference, and more we're seeing these days employers providing absolutely factual references, i.e. this person worked for us between this date and that date, and just about, and that's their job title was, and nothing more. But Laura's right, if they do write a reference, it has to be accurate. They can't put in a reference anything that hasn't been discussed with you. So it's about being honourable, I suppose. One thing I would say is to anybody who is moving on, and this applies possibly to agency workers in particular, I would always try and get a reference and see the reference before I left an employment situation. And I myself have been an agency worker, and I would always get the reference and before I left, because it's much easier to challenge a reference if you're still there and you can do it face to face, or even virtually face to face. But I think the civil action thing, I would have thought it would come under the 6 years time limit. So, you know, if this had happened 5 years ago, you need to be getting on with it, as I think Laura might already have said.
Yeah, thanks, Leanne. And obviously you're all lit up there, so I'll ask you the next question that's there, and it's I have whistleblown and was left in a team without adequate staffing, so felt unsupported and bullied out of the job. How do I explain this on a job application? I think you're giving a great answer, Leanne, but you're on mute, unfortunately. So.
It was a brilliant answer. Sorry you all missed it.
Right.
So, discipline for harassment. It depends really what the harassment was about. Oh, hang on.
It was like I have whistleblown and was left in a team without adequate staffing. So this person felt unsupported and bullied out of the job. But they're thinking about how do they explain this on the job application about leaving.
Yeah, that's where I started. That actually there's no reason to explain it on job applications. I suppose if there was a gap in your employment between your previous employment and getting a new one, then employers might ask you what has happened during that period. But I certainly wouldn't put details like that on a job application. if you were to be asked the question, it's never a good idea to disrespect or to say bad things about a previous employer, but I think you can be fairly honest and say the situation as you understood it. I mean, it's interesting because, of course, whistleblowers are protected in law. So if you had come to us with this situation, we would have taken action in terms of deploying your rights as a whistleblower. And again, that gets more complicated. But it sounds to me as though you've left your job, moving on, and that you really just want to draw a line in the sand and move forward. I don't. What do others think? Would you recommend that people talk about that in a job application?
Paul, would you like to come in there? Oh, sorry, Laura, you're lit up there. So
sorry,
you
I kind of jumped in there. So I mean, I personally don't feel a need for it to be included in a job application unless it's specifically asked. But I don't see why it would be specifically asked. Did you whistleblow in your last organisation? You can put all sorts of reasons as for why you've left your last job if you wanted to, which wouldn't be dishonest, to pursue other career opportunities. Whatever the reason is, you can put without being dishonest about it. I think if you were asked at interview in terms of there been a gap in your CV, you would probably be honest about it to a degree, but you don't need to go into great detail. Simply saying, I whistleblew in my last organisation and it did create some difficulties, so I decided to move on, would be quite straightforward to me.
Yeah, thanks, Laura. And Paul, anything to add to that?
I agree. I don't think it's necessarily wise to tell the company that's about to employ you that you successfully created a nightmare situation for your old employer or took them to a tribunal.
Yeah, thanks, Paul. And the organisation is going really well. So since you're lit up, I'll ask you the next legal question, Paul. And it says, I've been told my job is up for TUPE, that's TUPE. What does this mean and my rights?
So TUPE is the abbreviation for the Transfer of Undertakings Protection of Employment Regulations, which have been around since the early 1980s, and they derive from the European Acquired Rights Directive. Historically, if your employer sold their business to a different company, then the position at common law was that your employment came to an end and you had to start afresh, so to speak, with the new employer. By virtue of TUPE, we can be cleverer than that, and the effect of the regulations is to preserve your employment as it transfers between the two employers. So the position once you start with a new employer is that you're treated for all important respects as if your employment with that employer had started when your employment with the original employer began. So if you've got 10 years service when you transfer, then a year later you'll have 11 years service with the new employer, even though you've only been there a year. So the first thing is preservation of your rights. And secondly, with some limited exceptions, the new employer can't simply change willy-nilly your terms and conditions. So they acquire you with all the rights, terms and conditions that you had from your previous employment, and the law puts obstacles in their way if they want to try, for example, to harmonise terms and conditions so that you fit in more neatly with the new workforce. So it's interesting that a lot of commentators are suggesting that post-Brexit, perhaps one of the things that we're most likely to see the government introduce is a change in that respect to make it easier for employers to harmonise terms and conditions post-TUPE, because they'll no longer be bound not to do so under European law. So that's quite an interesting point.
Thanks, Paul. And Leanne, anything to add on to the 2P question? No, that was a no. I read your lips there, even though you're on mute. So, Laura, anything you want to add to that question?
No, I think that one's been well covered by Paul.
Perfect. And since I've got you on the live stream, Laura, I'll ask you the question which came in. I'll read it to you. It says, my line manager was disciplined for harassment. My employer did not report this to the regulator, and this manager is now working in another area. Do I have any obligation to report this?
I'll turn myself off mute. I think obligation is quite a strong word. I think the obligation in this case would have been with the employer if they felt that it was necessary to refer the person concerned to the regulator. Now that would be dependent on what the outcome. I mean, it said disciplined. I don't know whether that means that someone faced actually a disciplinary sanction, whether they were just under a disciplinary investigation and it was held there was no case to answer, for example. And again, we need more details on that really, because sometimes just because something has been investigated doesn't mean there's been an actual disciplinary outcome. So that could have influenced the employer's decision as to whether or not they referred to the regulator, which I would imagine in this case would be Social Work England. Now, employers have guidance which is on the Social Work England website about there is guidance on when to refer a social worker and when not to refer a social worker, and a lot of the decision making around this again will be influenced by the outcome of the actual disciplinary investigation or the disciplinary process. In terms of your obligation, I think that ultimately comes down to yourself. I would say that if you've got real concerns about the practice of this person, you can raise the concern with your employer again, and then it's ultimately, if you do feel that there are real concerns about this person practicing as a social worker, you can make that decision to refer to the regulator yourself, and it's ultimately up to you as to whether or not you feel a referral needs to be made. I don't think I can comment on whether you've got a duty to do that at the moment. Like I say, generally the duty would have been with the employer doing that investigation as opposed to yourself. What I would say is that Social Work England have got, again, guidance on their website about making referrals and when a referral should be made, under what circumstances, for example. And I think that guidance would hopefully help to inform your decision as to whether or not you did decide to speak to the regulator about the issue.
Thanks, Laura. I'm also aware of the time, so I will ask Paul and Leanne if they've got any brief comments. So, Paul, anything to add to that note? And Leanne, anything to add to that one?
Yeah, first of all, not just Social Work England, all the regulators have this information on their website, so that's the first port of call to have a look and see what your duty is. I think one important factor is if you feel that the behaviour is serious enough and you don't report it, then technically you could be in breach of the standards yourself. So it's really important to look on the standards of the regulator and see if they give you any further guidance, and be aware of what sort of standards you are required to maintain as well.
Thanks, Leanne, and I've got you on there, so I'll ask the next question to you. I'm just going to read that now. Do I have a right to work part-time to care for my children and elderly parents? So this person's asking, do I have a right to work part-time to care for my children and elderly parents?
Sorry, you don't have the right to do it. You can make an application to do it, and I would certainly hope that most employers would look on caring responsibilities in that way, compassionately. So first thing to do is to talk to your employer and ask them if they're prepared to allow you to go part-time. We're back to the old chestnut of business requirements, etc., and they may say, well, no, sorry, we need this post to be filled full-time. There are options. Obviously, you might be able to ask for a a flexible working request. We've talked about that a bit earlier on. You might also look at doing perhaps a job share or something like that, where you buddy up with somebody else who can do half time, so that the full-time role is filled, but you're only doing half of it. I would say larger employers generally have more flexibility to do this. And I don't think I mentioned, if you're applying for a flexible working request, you do, as we've said before, have to work for them, for your employer, for 26 weeks or more. So do bear that in mind as well. But I think the starting point is talk to your employer and see how helpful they might be.
Thanks, Leah. Laura, anything to add to that one? And Paul, anything to add?
Yeah, well, I'll throw it in relation to the children part of that. Is there a right to work part-time to care for children? I agree entirely with Leanne. There's no right as such, but the tribunals recognise still that childcare tends to be the mother's responsibility more often than not. So the employer that says, I require you to work full-time, runs the risk that we can argue, well, that requirement indirectly discriminates against women. Because here is my member client who can't comply with the requirement to work full-time because of childcare needs, and more women than men are disadvantaged by a requirement such as that. So that can give rise to quite a strong remedy in what is called indirect discrimination. It's not been done because the member's a woman, it's been done for a different reason, but it's disproportionately affecting women. And the great thing about being able to pursue a claim for discrimination is, firstly, you can lodge a grievance, the union can support you internally in relation to that. That will create a framework within which you can try and resolve it and maybe get your part-time terms. And if you do pursue it to tribunal, then in both events you're covered from any repercussions by the law of what is called victimisation, which prevents the employer from taking action against you simply because you've raised an issue about discrimination. And in fact, you could even be wrong about the discrimination and you'll still be protected from victimisation if the employer takes steps because you've raised that issue. So quite a strong weapon in the armoury of the unions, I think, in an appropriate case where childcare is concerned.
Thank you, Paul. And the next questions came in. I'll direct that to you, Paul. It's quite a topical question, actually. It says, I work for an NHS trust and our team are being asked to justify reasons for not wanting a COVID vaccine if we decline. This seems to be getting more frequent and quite intrusive regarding the reasons, particularly for medical reasons. Is there any guidance on workers being forced to get the vaccine, and how much info can my employer ask if they decline? So it's, I don't know.
It's an absolutely fascinating question, and I was delivering a webinar about claims, employment law and similar claims during the pandemic just a couple of weeks ago, and this never came up. So whoever the questioner is, really interesting and difficult, I think. And my first reaction is to say no. It's a step too far. Your employer's not there to say that you've got to have a needle stuck in your arm. There are human rights issues associated with it. It's an invasive intrusion into your personal life. And Article 8, I think it is, of the Convention on Human Rights protects our personal and private lives. So that would be my first thought. Secondly, in relation to the question of the employer who asks information, ask for information about why you're refusing. There's a GDPR issue there. That's personal data, and it relates to health. So it's what used to be called sensitive personal data, now special category personal data. And again, that might be a good reason to refuse. But I asked this question, and this is what, since the question cropped up in chat a few minutes ago, this is what's been going over and over in my mind, that especially if you're working for an NHS trust, and given how we know some trusts have been nearly overwhelmed by the pandemic, might it be that a tribunal faced with somebody who'd been sacked for refusing to go down the route of having a vaccine, might a tribunal say, well, there was what we talk about as some other substantial reason for dismissal, It's not misconduct to say no. It's not lack of capability. It's not redundancy. But might a tribunal say that given the exceptional circumstances of this year over all years, then a health sector-based employer had a right to say that you've got to take those exceptional steps, regardless of all the things that I've already mentioned, to protect everybody else in the workforce? And the answer to that is, I don't know. This is new law. We're going to see all kinds of different types of legal claims, I think, pursued in the few months and years, frankly, coming from now. And this is one of them, perhaps. My first position would be that if I was representing the member who came to me with that query, I would say GDPR, right to privacy, personal life, intrusive, invasive, get lost. And I'd begin, I think, by being very robust about it. But if the employer then said, right, I'm going to discipline and the outcome might be that you're sacked, yeah, well, I maybe just want to think twice.
Yeah, thanks, Paul. I'll move on to the next question just to keep them going. I'll direct it to you, Laura, if that's okay. It's my employer has asked me to come into an investigation meeting, and this person's asking, what should I do?
I think firstly, you need to clarify actually what the investigation is. I'm making the presumption here that it's an investigation meeting as part of a disciplinary process. Sometimes you can have investigation meetings as part of a grievance process, but I suppose if someone had raised a grievance, you would assume that they would know what the investigation meeting was about. So I think we need to just firstly establish what the actual investigation meeting is. If it is a disciplinary investigation meeting, there should be a letter outlining, whether that someone's being accused of misconduct, gross misconduct, or a brief outline of what the allegations are. They don't normally give details, but they would normally give a brief outline. I think the thing I would say is that if you have been invited to an investigation meeting, contact the advice and representation team for advice and guidance on that, really. If you have been a member for 3 months and it's not a pre-existing issue or something that's occurred within that 3 months membership, then you would be entitled to representation from us with that process, and we could probably attend that meeting with you just to offer that support. And I think it's about seeking that advice quite early on and clarity over what it is. And if it is a disciplinary investigation, get hold of the disciplinary policy so you know what to expect and you know what the employer is supposed to be doing. Thanks,
Laura. Paul and Leanne, again, anything you want to add to that? Are you quite Paul's okay? Leanne, anything you want to add?
Well, you can be accompanied to an investigation meeting, and we would always recommend that you have somebody with you. I used to say to be a second pair of ears, but also perhaps to make notes and also to make sure that you're being treated fairly and appropriately, and you're not being the questions aren't oppressive or whatever. One thing I would say, though, is as a registered social worker, you're obliged to work with employers undertaking investigations, and so you have an obligation to cooperate, and if you refuse, it can be referred to the regulator. That's pretty extreme, but we have come across situations where that has happened. I don't think there's anything more I can add to that.
That's fine, Leanne. So since I've got you on, I'll direct the next question to you again. We've got 5 minutes to go, so we'll keep them brief. But I'm the person saying I'm returning to work after a period of sickness and my employer isn't being supportive. What can I do?
You need to have a look at the organisation's policies and procedures around sickness absence to see what you can reasonably expect from them. If you've been off sick for a very long time, I think it would be reasonable to expect more support than if you just had a short-term illness, but it does depend on the circumstances. You might be expected to attend an occupational health assessment, which is to give the employer guidance on about any reasonable adjustments that they might need to put in place to enable you to get back to work. And of course, it's the sort of thing that you can call us as your trade union if you're a member. We also, the Social Workers Union also have SWU union contacts in a number of local authorities and organisations, and particularly if this is something that needs to take place quickly and we can't respond to your needs straight away, sometimes the union contacts can help you with your first stage sickness absence meetings. But as I say, the most important thing is look at the policies and procedures of the company.
Brilliant answer, Leanne. And just for the time, let's move on to the next question now. And Paul, we'll start with you. And this is quite an important one. It's from a non-member, actually. They've identified as a non-member. It said, someone told me that SWU doesn't have collective bargaining. What does that mean? And how important is it for representation? So any thoughts on that, Paul? And I'll ask Laura and Leanne as well.
Briefly, collective bargaining rights go to the ability to negotiate with the employer in relation to, for example, pay on the annual pay round. But representation rights don't depend on recognition or collective bargaining. And so SWU's position, I know, is that it is the union for social workers. It's a specialist and smaller union that dedicates itself to that. And has a right, because it's an independent, certified trade union, to have its officers and reps attend at disciplinaries and grievances on behalf of its members, and that's despite the fact that it might not be recognised for collective bargaining purposes.
Thanks, Paul. 3 minutes to go, Leanne. Can you get anything in a nutshell there?
Yeah, Section 10 of the Employment Rights Act says that an employee has the right to be represented by an official of a certified trade union, and that trade union, as Paul said, doesn't have to be recognised by the employer, and it can be a trade union representative, a trade union official of their own choice. So it doesn't matter that the employer is saying we don't recognise you or whatever. It's the employee's choice.
Thanks, Leanne. Laura, anything to add there?
Just very briefly, we might not have the collective bargaining rights, but what we do and regularly do as part of our team is do individual consultations, and actually we can get far better results for members by sitting and doing individual one-to-one consultations and dealing with individual terms and conditions, and that's something that I think generally our team do quite well and get positive results for our members.
Perfect. So unfortunately, we're coming to the end now. We've got a lot of questions, so if you've enjoyed this, please let us know. And I think by the range of questions, it's something for us to look at in the future. But I'll leave it to Leanne, Paul and Laura to have final words. Just anything you want to add in the next 30 seconds. Leanne, any final comments before we say goodnight and we enjoy a glass of juice?
Make sure you're a member of a trade union, and preferably the Social Workers Union.
Thanks, Leanne. Paul?
I'll repeat that. We lawyers can do all sorts of good things in tribunals, but most problems at work are resolved by negotiation, not litigation. Thanks, Laura. You've got a final minute if there's anything you want to say.
Yeah, I mean, I would echo what Leanne and Paul have said, and I think the one thing I have learned since doing this job, which I've been doing for around 2.5 years now, is that actually there is a huge value to members, and the feedback we get is that, okay, this wasn't an easy process and it was a really difficult process, but having somebody by my side throughout it, guiding me through it and offering that support and advocating on their behalf when needed has made a big difference to members. And I would just urge anybody, you know, having seen what I've seen in this job, there is a huge benefit to being in a union, absolutely.
Thanks, Laura. And I suppose my final comment is my wish that all unions would work together. As I said, our door is always open, and I just wish that it would be knocked by other unions for us to work together. So let's hope that will happen in 2021. I'll conclude. We've got 10 seconds left. This joke was voted as best joke of the year from the Gold magazine. It's, what is Dominic Cummings' favourite Christmas song? And the answer is Driving Home for Christmas. So I'll leave you with a wee giggle there. So good night, everyone, and thanks for joining us, and thanks for the excellent panelists who sort of gave some really skillful answers. Good night now. Bye.